Discrimination based on religion. A family's religious practices differ from those of the majority of people in the neighborhood. Thus, the landlord declines them to rent an apartment. This is an example of discrimination based on religion. This is discrimination when the family's right to fair of accommodation is violated and housing is denied on basis of religious faith. We cannot discriminate based on religion because it violates the principles of equality, freedom, belief, and human rights. Discriminating against someone because of their religion marginalizes individuals and fosters division and intolerance within society. Additionally, religious discrimination is prohibited by law in many jurisdictions to protect individuals from unfair treatment, and it ensures their right to practice their religion without any fear. Moving on to discrimination based on disability. A company consistently overlooks employees with some disabilities for promotional opportunities and denies them access to training programs that could help enhance their skills. Instead, employees with lesser skills but without any disabilities are favored for career development initiatives. This is an example of discrimination based on disability. Since it prevents people with disabilities from having same opportunities of career development and progress as other people without disabilities, this is a discrimination based on disability. The employer restricts the professional growth and promotion of employees with disabilities by keeping them out of training programs and promotional possibilities. While discrimination based on disability is generally prohibited, there are specific situations where an employer may justify differential treatment. For example, bona fide occupational requirement. If a particular work responsibility rarely demands certain physical or mental capabilities that a person with a disability cannot reasonably fulfill, the employer may discriminate on this basis. However, this must be proven as a genuine occupational requirement and not merely a pretext for discrimination. When an employer asks about a candidate's original place of birth before offering a job, they are potentially violating the protected ground of discrimination based on the place of origin. In Ontario, as in many other jurisdictions, discriminating against someone based on their place of origin is unlawful and under human rights legislation. The question they ought to have asked instead is related to candidates' ability to legally work in the country. For example, they could ask if the candidate is legally eligible to work in Canada or how long their work permit allows them to work. This question focuses on candidates' authorization to work without delving into their personal background or origin. The law in Ontario prohibits discrimination based on place of origin to promote fairness, equality, and diversity in the workplace. Asking about a candidate's place of origin can lead to biased assumptions, stereotypes, and eventually unfair treatment. It can eventually lead to discrimination against individuals from certain ethnic or cultural backgrounds and restrict their opportunities for employment based on irrelevant factors. By focusing on eligibility of work rather than place of origin, employers can ensure they maintain a fair and inclusive hiring process. Discrimination based on certain grounds, including race, ancestry, place of origin, sex, sexual orientation, gender identity, and disability, is explicitly prohibited by the Human Rights Code, Ontario. However, this code does not specifically mention tattoos as a protected ground. That said, the Ontario Human Rights Commission (OHRC), which enforces this code, has offered guidelines regarding the subject of appearance-related discrimination, which may include circumstances involving tattoos. Discrimination based on appearances may be considered a form of discrimination under the grounds of race, ancestry, or other protected grounds, if the treatment is linked to those protected characteristics. In the case tattoos, if an employer refuses to hire someone solely because they have tattoos, and if those tattoos are linked to a protected ground such as religion or ethnicity, it could be considered discrimination under the OHRC. However, if the decision not to hire someone is based solely on personal preferences or aesthetic reasons unrelated to any religious grounds, it may not necessarily constitute discrimination under the law. Ultimately, each case would need to be assessed individually to determine whether discrimination has occurred or not. Employers are encouraged to adopt inclusive hiring practices and consider qualifications, skills, and abilities rather than a non-job related characteristics such as tattoos.